intent. Second, outrageous conduct. That's quite a word, outrageous, isn't it? We're going to come back to that. And third, severe mental suffering. Intent, outrageous conduct, severe mental suffering. What do we mean by intent? Intent, in a case of intentional infliction of emotional distress, means a desire or knowledge to a substantial certainty that the plaintiff will experience emotional distress. Desire or knowledge to a substantial certainty that the plaintiff will experience emotional distress. Now, here are two cases that illustrate the way intent can become an issue in this tort. One case involved a mother who left her 9-year-old daughter in the care of a teenaged male babysitter, and mother went out for the evening. And when she came back, sent the babysitter home, the daughter eventually informed the mother that the babysitter had sexually molested her. The mother freaked out and sued the babysitter for intentional infliction of emotional distress. Of course, the child has many causes of action, but let's just concern ourselves now with the mother's lawsuit. The babysitter says, well, the intent element is lacking because I did not desire or know that the mother would experience emotional distress. And the court said, the name of the case is somebody against Christensen, or Christensen against somebody, maybe you've read it. The court said that when the babysitter molested the child, he must have known that a 9-year-old daughter would eventually tell her mother about it and that the mother would freak out. So the court said the babysitter did have a substantial certainty that his conduct would result in emotional distress in the mother. Compare that with another case, which I think is called Taylor against Vallelonga. You may have read that one, or you may read that one. In that case, a daughter was looking out the window when she saw two defendants beat her father up. And she sued those two defendants for intentional infliction of emotional distress. Again, the father had lots of lawsuits against them, but let's just talk about the daughter's lawsuit. She sued for intentional infliction of emotional distress, and she lost her case because the court said that the defendants neither desired nor knew that their act of beating up her father would result in emotional distress to the daughter. Now, what's the difference between those two cases? I'll tell you what the difference is. They come from different states and they come from different judges, that's all. In the Christensen case, a judge could very well have come to the conclusion that since the mother was not present, the babysitter had no way of knowing that his act would result in mental suffering in the mother. And in the Taylor against Vallelonga case, the court could very well have come to the opposite conclusion that it did, and could have said, well, the bad guys must have known when they beat this fellow up that he would go home to some loved one, a daughter or somebody, who would experience mental suffering as a result of seeing him hurt. Remember that our job is not to come to conclusions, but to make arguments that justify our conclusions. You know, by and large, the conclusions we reach is going to depend upon who hired us. If the plaintiff hired us, we're going to say, yes, there was intent. If the defendant hired us, we're going to say, no, there wasn't intent. But anybody can do that. You don't have to go to law school to do that. You can go out in the street and find somebody and say, was there intent? And the chances are 50-50 that that person will agree with the court. What makes us lawyers is our ability to persuade, to justify the conclusion that we've reached. Okay, we've talked about intent. The second element is outrageous conduct. Outrageous conduct. What is outrageous? Well, although it sounds like a word with a very general meaning, the courts have actually given it quite a specific meaning. When we use the expression outrageous conduct, we mean conduct that exceeds all the bounds normally tolerated by decent society. And there's more. Conduct that exceeds all the bounds normally tolerated by decent society, and that is extremely likely, almost inevitable, to produce mental suffering in, here comes the objective standard again, in the ordinary person. Conduct that exceeds all the bounds normally tolerated by decent society and is extremely likely to produce mental suffering in the ordinary person. Once again, you've got to remember our exception to that objective standard. If the defendant knows of the plaintiff's special sensitivity, then the defendant's conduct might be outrageous even though it would not produce suffering in the ordinary person. Now, you're probably going to read or have read a case called Slocum against Food Fair, in which a nice lady went up to a guy in a supermarket and said, "Can you tell me where the peas are?" And he said, "You'll have to find them yourself. You stink to me." And she got so upset by it, she had a heart attack or something, and she sued for intentional infliction of emotional distress. And the court concluded that the insult delivered by the store employee was not outrageous, because decent society normally does tolerate insults, especially in this society where we prize freedom of speech so highly. And second of all, that it really is not likely that the ordinary person would experience great suffering upon being insulted that way. But maybe you're going to read another case, a case of Contreras against Crown Zellerbach, in which the defendant, who was the plaintiff's supervisor or employer, continually insulted the plaintiff by making reference to the plaintiff's ethnicity, continually used ethnic slurs to insult the plaintiff. And the court in that case said the plaintiff had a special sensitivity to racial slurs, which most members of ethnic minorities have because they've had to live with such slurs all their life. And the court said the defendant must have known about that special sensitivity, and that brought that case within the exception for known special sensitivities and made the conduct outrageous when it might not otherwise have been outrageous. The third element is severe mental suffering. Severe mental suffering. Severe mental suffering means mental suffering or emotional distress which is very serious and which would seriously discommode, inconvenience, make uncomfortable the ordinary person. However, some jurisdictions go even further. Some jurisdictions say mental distress or emotional distress is not sufficiently severe unless it produces some physical symptoms. Unless the plaintiff was so upset that she vomited, or the plaintiff was so upset that he had a heart attack, or the plaintiff was so upset that she got ulcers, or the plaintiff was so upset that all his hair fell out, or the plaintiff was so upset that she had a miscarriage, or the plaintiff was so upset that he had a stroke. All of these are possible physical manifestations of mental distress. And in some jurisdictions, mental suffering is not sufficiently severe to result in liability unless the mental suffering produces a physical manifestation. All right, we've talked about 4 intentional invasions of the person. Remember when we began this discussion, I said there are 3 factors to be considered in a tort case. One is basis of liability, and we've looked at intent as a basis of liability. The second is proximate cause and damage. Now, we're not going to talk about proximate cause and damage yet because most of the time, proximate cause and damage don't present issues in intentional tort cases. Sometimes they do, but most of the time they don't. And proximate cause and damage is difficult enough concept that we're going to postpone it for a while until we've got a little more tort law under our belt. The third factor that usually has to be considered in a tort case is the possibility of affirmative defenses. We've talked about 4 intentional invasions of the person. Let's talk about some affirmative defenses that apply to those intentional invasions of the person. We're going to talk about 3 affirmative defenses that are so similar that we can talk about them as if they were one. Defense of self or self-defense, defense of others, which is sometimes called defense of another, and defense of property. Self-defense, defense of another, defense of property. All of these are rules of law which may give you a privilege to use force against another person. And so it may give you a privilege to do something which would otherwise be a battery or an assault or a false imprisonment or an intentional infliction of emotional distress. All 3 of these affirmative defenses have the same essential elements. All 3 of them are privileges to prevent a tort by using reasonable force. 2 elements: prevent a tort. Remember that these privileges, self-defense, defense of others, defense of property, only apply if the person using force is attempting to prevent a tort from being committed against him, against another person, against his or her property. So if somebody hits me over the head with a stick,